There we go. Good evening, everyone. Welcome to Mine and Di's segment of Keep Talking Till They're Walking. I'd like to say a big thank you to our lovely guest, Kate, who we've actually had on before, and we're delighted that she's come back again. So thank you so much for coming back and joining us. It's lovely.
Thank you so much for having me.
Oh, you're welcome. The pleasure's all ours, Kate. All ours. Go on. Sorry.
No, I was just going to say we did get a little shout out because Jerry was on one of the previous shows a couple of hours ago, and he mentioned that you would be here with us now. So people have been looking forward to seeing you here with us again. Okay. So it'd be nice to have a recap on how things have been with you since over the last 8 months or so, isn't it?
Yeah, it's been a while. Well, the most exciting thing is that the last time we were on, I was on with you. We had just secured the release of our client, Stephanie Spurgeon. And then about 2 weeks after the broadcast, our client, Amanda Broomfield, and now Amanda Langley, she's gotten married, was released. Yeah, was released just after. So it was, and we spent some time talking about that case when I was on last time, and it's amazing that she's out now.
Yeah.
There's one. So I'm sorry.
We were so pleased to see that after we'd spoken to you. It's great.
There's one sort of systemic issue with it, which is sad, which is that she wasn't exonerated. She was released. She agreed to stop fighting her post-conviction petition. In exchange for that, the state agreed to immediately release her, to resentence her to an immediate release. So, she still is convicted of a felony. She still has to live under that shadow, but she's completely, off paper, out of prison, and with her family, which is so important.
Is that different to, it wasn't an Alford plea, was it? Is that different?
It wasn't an Alford plea. So in an Alford plea situation, you'd get released, and the conviction would be overturned. You'd get released, and then it would be tried again. And then at that retrial, if you chose, you could enter an Alford plea. So that's not what happened. What happened with her is the state agreed to an immediate resentencing, and the agreement was to release her if she just stopped fighting.
So no more jail time.
So that's interesting that you would that's something that can happen, because why would somebody release a person if just for the fact that they would stop fighting their post conviction? Because wouldn't that mean that they think that person's innocent or deserves to be released?
It could mean that. It could also mean, there are a variety of legal technicalities that might result in the state losing a post-conviction petition, even with a person who was still guilty. So it's possible, that they believed. I'm confident they believe she's still guilty. They've said as much, but I think they were concerned about their chances at the hearing, and so it was this way they get to preserve their conviction. Yeah.
Mm. Wow.
And do you think, would it does it cost them money? Would it cost them money? So do you think it could have been a money thing?
Yeah, I don't have a lot of insight in this individual case about why why this was the choice. But yes, this litigation can be really expensive. It can take up a lot of staff time. Paying experts is expensive, that kind of thing. So sure, it absolutely could have been a money issue, and sometimes it is. I don't know, and sometimes they do it for other reasons. They're unable to secure the appearance of a witness. There are lots of other reasons, but yeah, it could be any number of things. I'm not exactly sure what caused them to to agree to this resolution in this case.
Were you surprised? Did it come
a little bit?
Yeah,
because they were preparing like we were going to have a hearing and we were going to, it's a shame, in so many of these cases, it's a shame that the resolution is a really good one for Amanda in that she gets to be free.
Yeah.
But it's unfortunate that she's still convicted, and it's unfortunate that this is the resolution that we came to after all of this, time and preparation, because we've filed the motion many years ago, and so it's kind of too bad that if this was the resolution, that we weren't able to come to it years ago.
And just remind me again, how long had she served?
She, I don't recall off the top of my head, almost a decade. About 9.5 years.
I think, and so having that conviction still on top of, still stamped to her name, basically, how does that affect her life now then in the outside world?
Right. So that's the sad part, right? So when you have a serious felony conviction on your record, it inhibits lots of things in life. She's been very fortunate in that she's been able to find a job, but for many people, finding employment after a conviction like that is extremely difficult. You're barred from holding certain professional licenses. You're barred from working in certain jobs. You can't vote. You might be barred from doing things like becoming a foster or an adoptive parent. There are a lot of collateral consequences. Certainly, if you are not an American citizen and you have that on your record, and this is a calculus that we go through often with clients who aren't citizens, it can affect your immigration status. You can be, you could be deported, that kind of thing. So. Yeah, that wasn't an issue for her, but it can certainly be an issue.
And and I would be right in thinking she wouldn't be able, like a lot of wrongfully convicted people can sue the state or sue. She can't do that.
No,
for time served or being.
And is that?
I mean, for some people, they're just not bothered, are they? Like she would rather get out and be out. But like you say, that is such a downside to.
Right. Well, one sort of common issue that we run into in our cases is that we can't guarantee, no lawyer can ever guarantee their client a result, right? So we can never say, the classic example of the unethical statement is, if you hire me, you won't get convicted, right?
Yeah.
That would be, but there are much more subtle examples of not being able to guarantee a client a result. The only way that we could promise her what was going to happen. So, so let's say you're having a hearing on Monday and the state says, if you don't continue to fight the hearing, then we'll ask for your client to be released on Monday. Then I have to go back to my client and say, the only thing I can promise is that if you agree to what they're saying, that they'll let you out on Monday, right? Because if you wait for the case to work its way through the system, there's obviously the hearing, and you never know what the judge is going to do. And then in post-conviction, every party appeals. So even if you win, the state can appeal on post-conviction, which is not the case in most criminal trials. So it goes on.
Where was she up to with her post-conviction? How long had she been, or how long had you been involved?
We filed the post-conviction petition in 2014.
Yeah.
So we'd had the case. We got the case before we filed the petition. So we'd represented her for more than 6 years at the time.
Right.
Yeah.
So she was quite far into the post-conviction.
Yeah, well, we had actually gone through a series of other appellate issues. Initially, the case got denied without a hearing, and we appealed that, and the appellate court agreed that she should have received a hearing, and so then we got sent back down, and then because of COVID, we got set over a couple of times, and so just delay after delay. I really feel for clients who get, just pulled around in the system in that way.
Well, you just reminded me actually of something that I wanted to ask you about, because, when somebody's convicted of a crime, they're not then entitled to a lawyer, are they? They have to pay for it themselves.
You're entitled to a lawyer. In most places, most situations, you're entitled to a lawyer throughout your trial and throughout your appeal. So, but after your appellate procedure is exhausted, so for a lot of people, that means they appealed all the way up to the Supreme Court. The Supreme Court says we don't want to hear it. Or perhaps they've appealed to their state Supreme Court and been denied. And then at that time, you are no longer entitled to, most of the time, you're no longer entitled to a lawyer. So that's why there are these nonprofit innocence efforts who step in at that point, because you aren't entitled. I mean, the state won't pay. And so that's why, so many of us do this work as nonprofit organizations.
Yeah. And in terms of because that's one of the things I was wondering about, when you're not entitled to a lawyer, but you are entitled to appeal. Why is it that a judge can just go, no, denied, without even looking at it? Because if you're entitled to an appeal, surely they should at least look and see whether there's anything behind it, without just going, no, denied.
Oh, sorry. Sometimes that's what the appellate court says. So sometimes if a judge looks at the case and says, I don't need to hear this, I can make a decision based only on the written record, often the lawyers say, that's wrong. You have to allow us to be heard and hear the evidence in this case. And at least in Amanda's case, then the appellate court agreed and said you have to hear the new evidence. But there's a subtle distinction between what we would call kind of a normal appellate procedure and then post-conviction procedure. You're actually not always entitled to be heard. In a post-conviction case, you're entitled to an appeal if you're a criminal defendant and you're convicted, but depending on the circumstances, you may not actually be entitled to have your case reheard on a post-conviction motion, and that happens pretty frequently. So, and then courts have wide latitude. I mean, they can say we don't want to hear it. They can hear the new evidence and say it's not persuasive. I don't believe it. There are kind of a lot of pitfalls. It's not. Even if you do get the hearing, it's not certainly not a guarantee.
Yeah, and I suppose those sorts of things would be the reason why it takes so long.
One of the interesting things that we've been seeing with COVID is that there have been all kinds of delays for all kinds of criminal cases because of the pandemic. And because people who are on a post-conviction motion are not entitled to the same process, they're not entitled to, for example, a speedy hearing. They may not be entitled to a hearing at all. We're seeing people get set over and over again because maybe there's a trial that's been delayed where the person has a right to a speedy trial, right? So they'll kind of jump ahead. So that's one of the things that I've noticed since the pandemic is that our cases are getting just set over and set over.
Yeah. This pandemic.
Yeah. Well, I was just going to ask about Stephanie as well. So with Stephanie, Stephanie had just been released a couple of weeks before you came on our last live, and so she was waiting for. She'd been released on like an electronic tag, hadn't she? So she was then just refresh my memory.
She was waiting for a trial, wasn't she?
Trial, yeah.
She continues to await a new trial. Yeah.
Oh, right.
Because
okay,
she's, so she's
out, but she's, yeah. And so where is it again, because of COVID, has that sort of slowed things down?
Yes, for sure. Yeah. And, this is something that makes a lot of sense. People who are currently being held in custody are prioritized often in kind of this trial order, right? And so because she is not incarcerated, there are folks who might be heard before her.
Oh yeah.
It's just a waiting game for her now.
Yeah, and we really hope that the state will do the right thing and choose not to re-prosecute her in the end, because she's innocent. but we don't know. We're preparing to go to trial.
Yeah, because I watched that Trial 4 on Netflix, and they had the case on there where he was about to, well, he would have had his 4th trial, and at the very last minute, the state came in and kind of, you know, overturned it. They said he was out. He was just like Stephanie. He was out and awaiting another trial. But he'd had 2 trials that the jury had.
It was a
hung jury, yeah. And then the 3rd one, he got found guilty, and then so he spent time in prison, and then he was out, and then waiting on a trial, and then right at the very last minute, the state turned around and said, "We'll drop it," which was a total shock. Like, no, you know, and it's always, you know, good when that's happens, because like I was just saying to you before, it's like, so the news about you know, it's obviously it's upsetting that, you know, she hasn't been exonerated, but she's free.
Yeah.
And because there's so much in the wrongful conviction world, there's so much sadness and, you know, so much heartbreak. It's when you see like a nice story, it comes, you know, and someone gets out. That's why we're here. That's what we're trying to achieve. Well, I say we, but, you know, we're just voices. We don't do what
we
you
like
do.
to shout about those ones.
Oh, yes, we do. Yeah,
the free ones. Yeah.
Yeah,
but
and
it's
there we
so
go.
true.
It's
so true that it's important to it's so true that it's important to make people aware of these issues, because they, for many years, people did not understand how common wrongful conviction was, and it's to your credit and folks like you that you know, the average, you know, person understands that people get wrongfully convicted. People get convicted of crimes they didn't commit.
Yeah, honestly, Kate, before I'd watched Making a Murderer, I wouldn't have thought for 1 minute that, like, cops tell lie or tamper with evidence, or, you know, the prosecution pull shady tricks. You know, it completely opened my eyes, and because of watching Making a Murderer, that's what led me to look at other wrongful conviction cases, and I just didn't realize how many there are. You know, I didn't realize, you know, how bad it was. So yeah, I mean, it was shocking to me, absolutely shocking, and it was one of them things I couldn't just walk away from. It was like, well,
you're not alone there.
Yeah, it was like, I just can't sit here and not that I do a lot, but it's like, what can I do about this? What can I do, you know, to change this? And, you know, hopefully in time things will change, but it's so sad.
And talking about that though, because I mean, because the last time we had you on, you explained what the Centre for Integrity and Forensic Sciences was. Do you just want to give just a quick little brief, just in case there's people watching you who haven't seen that, just a quick little brief overview about what it is? And of course, you know, absolutely. The fact, I'm waffling now.
No. Absolutely. I'm the executive director of the Center for Integrity and Forensic Sciences, and we're a new nonprofit. We're incorporated in 2018 and really only had staff starting in 2019, so we're quite new. But we're the only organization devoted entirely to ensuring that the scientific evidence presented in criminal trials in particular is reliable and accurate. And so while we do have some things in common with like innocence efforts, we are not exclusively focused on guilt or innocence. Instead, what we're focused on is making sure that in any individual case, right, that you can depend on having good, solid, reliable, accurate forensic science in your case. And when, you know, we work on these issues and they can really run the gamut, right? There are classic forensic science disciplines that we now know they have problems, right? So, you know, fingerprints aren't as accurate as we used to think. You know, bite marks are junk science. Yeah. But also,
sorry, I just
no,
made me laugh when you said about the, you know, because I've seen there's another documentary about that, about, you know, teeth marks and yeah. Sorry, carry on.
No, I mean you're absolutely right. I mean that's, you know, it's junk science. It's been shown to be very unreliable. And so those are kind of the disciplines that people have heard of and know a lot about. But actually, in a lot of cases, there are these. This should be familiar to folks who watched Making a Murderer, right? Is that there are sometimes tests, evidence, opinions developed just for a particular case, right? So, you know, some of them will sound foreign to you because they're not very common. Matching a plastic bag found at a crime scene with a roll of plastic bags found at the suspect's home would be an example.
That's great.
Yeah,
we'd all get trapped with that one these days. The amount of plastic bags I've got in my drawer.
I know.
Yeah, or, you know, there's a case that's being heard by the Supreme Judicial Court of Massachusetts in the next month, and our organization filed an amicus, a friend of the court brief, and the evidence presented was evidence that was, you know, obtained in a pretty unscientific way and tested in an unreliable way about how long it would take a particular type of paint to dry at a crime scene. And they were trying to establish time of death by giving this testimony about the paint, but there were all sorts of problems with it, right? Because when you don't have standards, you can end up with all kinds of issues.
And as well, I mean, there's so many different factors that you'd have to consider, even if you were going to, like, think about how long it takes for paint to dry. Like, what surface is it on? Like, what environment is it in? Like, I know that's not what you're measuring it on, but like you say, like, if there are no standards, if they haven't done studies in it and, you know, tried out loads of different environments and surfaces and circumstances, then you just don't know. That's oh God.
Right. Yeah. I mean, and another really interesting development since we last spoke is that, and it got a lot of attention because of the Derek Chauvin's case, right? In
I'm going to ask you about that.
In Minneapolis, is the really important issues with error in forensic pathology and bias in forensic pathology. And the New York, you know, there was kind of this big story in the New York Times in the midst of the trial talking about a recent scientific study that found, unsurprisingly, that forensic pathologists are just as, you know, prone to error and bias as anyone else, and certainly any other physician. And that has been met with, you know, it's gotten a really mixed response in the forensic pathology community. Some folks have, you know, embraced it and said, yeah, absolutely, we make mistakes. All doctors make mistakes. Let's think of ways to reduce our error and bias. And others have simply argued about the study. Yeah.
You're going to find that though, aren't you? Like with any kind of change, people like to stay in their own little comfort zones. And that, like, I'm sure you said the last time you were on with us, like, people don't like to be told when they've done wrong. But that's the way that you move forward and improve, isn't it? If you're able to look at yourself and say, well, yeah, because, you know, I'm a nurse and I have to, like, always do that as part of my practice. So if somebody tells me you should have done it this way, then I should change my practice. I shouldn't be so stuck in my ways, because otherwise mistakes will continue to happen.
Absolutely.
Yeah.
We were going to ask you about the Chauvin verdict, actually, and whether you think that that's going to have, like, an impact on the future.
Yeah.
of.
It's so hard to know.
Yeah.
I mean, it's an example of a case in which there were such clear facts, right? It was a homicide, right, that happened in front of many witnesses, that was videotaped, that I mean, that it's very difficult to create an argument for anything but conviction in that case.
Yeah.
And it's been interesting to see. I mean, I was concerned knowing what I know about the bad science that makes its way into those kinds of cases, right? So, some of these things they did touch upon. So this idea that, there were some references in the trial, and I didn't, follow it really closely, but I was paying attention in particular to this forensic science issue. Because it comes up all the time in our cases. But also, there were some references to some really concerning concepts that are no longer really accepted. So this idea that someone could, this idea of excited delirium, which is not a well-defined entity, and doctors are divided about whether it's a diagnosis that should be used at all, and nobody really agrees what it is. But at its core, it's this idea that someone could have taken drugs and essentially like become so upset and drug-addled that they would, you hear descriptions of like superhuman strength and like not slowing down even when someone shoots them, right? So that kind of thing. And, this is not a medically described entity.
That would have to be some kind of psychotic episode, wouldn't it?
Yeah, I mean, yes. So there's the question, right, of whether it should be, whether it's a diagnosis. It's not really a diagnosis. It doesn't have a diagnostic code, but like whether it's a medical determination that should be used at all. Because if somebody is experiencing psychosis, that's a very known quantity, right? We understand what people who are experiencing psychosis are experiencing, or at least we know what it looks like from the outside. But this has been this interesting diagnosis that arose, as many things in the criminal legal system do, intertwined with ideas about race, ideas about socioeconomic status, ideas about drug use. And so it's pretty controversial, and problematic. The other thing you heard was this myth, right? This completely incorrect belief that if someone can speak, that they're getting adequate oxygen.
Yeah,
and that's
exactly.
a really, that's a really serious.
It's false.
Misconception.
Yeah. That's because we had to have training as part of the job that I do, for using physical restraint on people. And one of the main factors, because it's illegal over here to restrain someone in the prone position. So if you ever got into a physical restraint with somebody, you would have to, if you ended up with the person face down, you have to flip them over at some, I know that sounds really like not technical, but you have to put them into a safe position, and there has to be always somebody checking, can they breathe? Are they in a comfortable position? There's always somebody checking at that person. If it's necessary to hold them in a physical restraint, like, are they okay? And are the people who are in the restraint as well holding them, are they okay too? And they have to, that's a really integral part of the training that we did, because it's people's lives, and like what happened to George happens, and unfortunately that's what has the knock-on effect and causes a change to happen in your professional life.
And I guess that's all procedure. It's something that you have to do. But obviously, in this case, do you think he was just made an example of, Kate, or because I was thinking that I do hope this is not the start, but just like a tiny start of things to come where law enforcement or prosecutors are being held accountable. Because I think I do think they've probably made an example out of him, but I just hope it's the, I hope it starts to pave the way.
Yeah, I'm not sure. I'm not really sure how to answer that because, making an example of someone implies that they have been treated more harshly to make a point.
True, yeah.
And I think that, first of all, we don't know what his sentence is going to be. He hasn't been sentenced.
No,
but also, I mean, this was a homicide that was very credibly corroborated, right?
Yes.
It was recorded. People saw it. Yeah, I don't honestly know. I mean, I like many others, given, the history of our legal system, the history of our country, I was extremely concerned that, that this case might not end in a guilty verdict. But I don't know if there's any other reasonable result to reach when the evidence is so straightforward.
I totally get that. Yeah.
Not a lot of. Yeah. But what I hope that this does is the same thing that DNA did for the innocence movement, which is this. When we first started, I say we, I wasn't part of the innocence movement in 1989 because I was not old enough. But when the innocence movement started, DNA was this powerful tool to prove the truth of what people had been claiming for years and years. I mean, you hear, I'm from Chicago, and the Chicago area is sort of famous for these cases and for these terrible police brutality cases. And public defenders would say, people who were public defenders in the 70s would say, my client would come in and I knew that the police had beaten him, but I could not, and he knew it. I mean, he was telling me and I believed him, but we could never prove it. And that's sort of like what was going on before the advent of DNA and like a better understanding of why people get wrongfully convicted. We would, lawyers would say, my client is telling me he didn't do it and I believe him, but like, I can't prove it. And so what DNA did was help people understand that you could give a false confession, that a victim could make a wrong eyewitness identification, that forensic science evidence could be wrong. And so it's sort of a long way of getting there. But what I want to say about the Chauvin verdict is that I hope that it does for police brutality cases what DNA did for the innocence movement. So in other words, people will understand because they've seen video of it that they're, that these terrible injustices exist and happen with some regularity.
Yeah.
Absolutely.
Exactly. And sorry, my brain was going off in a lot of different directions. I don't know. You carry on. You know what happens to me, Jane? I start thinking of 5 different things at once, and none of them latch on.
Well, I've just popped this because I'm assuming this is a question for Kate from Rachel. I wonder what she thinks about. I think she means brain finger. Do you mean brain fingerprinting, Rachel? I think that's what she means.
I think that's probably what it is.
Yeah.
I forgot to put the chat up on it.
Yeah, I don't really know enough about it. I mean, just like anything else that's ever going to be used to provide evidence in a case or generate investigative leads, we have to know that whatever procedure is used was developed with, appropriately, right? Developed under the scientific method, independently verifiable. And I'm concerned about anything, new that promises some, extremely accurate, very reliable result where we don't know too much about how the information is being generated.
Yeah, that's fair. Yeah, that's fair.
And that's one of the things I wanted to ask.
I was just going to say this isn't one that we're seeing a lot. It doesn't mean it's not being used, but it hasn't, worked its way to us much yet. So it's not a technology that our office has had to dig into very much because we simply, it just hasn't. I'm aware of it, right? Because I'm aware of that stuff, but it's not something I've dug really heavily into because it hasn't really crossed my desk too much.
I mean, I'd never seen it before, because obviously I saw it on Making a Murderer, and I've not really heard anything about it since.
Maybe it's just because it's a new.
Maybe it's a new, because But yeah, I've not heard anything. Sorry, go on, Di.
One thing about evidence like that. Oh, sorry, I didn't mean to interrupt. I was just going to say that.
No, it's fine.
You carry on.
One thing about evidence like that is that even though it might sound unfair, like to a layperson, there is a discrepancy between something that the state introduces to convict somebody and a defendant is introducing to potentially, introduce doubt into the trial, right? So there are different, in our system, there are different responsibilities that each counsel has. And so, we often tend to look at evidence differently depending on the party that's introducing it, because we simply hold the state to a higher standard.
Right.
Yeah. I'm sorry, I just flicked that up because it was going back to the, I assume it's going back to the George Floyd thing, saying about the autopsy said drugs and heart problems also contributed to his death.
Yeah,
well,
so I'm familiar with that. That was Dr. Baker, who did the autopsy, is a physician who's familiar to many of us in the innocence movement because he's been a part of at least one exoneration that I know of. But there's, of course, a difference, right? So there are a couple things to say about an autopsy report. First of all, this study that I've referenced by E.T.L. Youre, a cognitive neuroscientist that was also co-authored by a number of other forensic pathologists, including like Jonathan Arden and Joy Carter. Maybe I may have gotten her name wrong, but at any rate,
yeah.
There's this issue in these kinds of cases, right? So forensic pathologists can make errors just like any other doctors can. And what this study showed, this study of decision-making in forensic pathologists, what it showed is that they're not immune to the kinds of biases that we all can experience. So in this study, doctors were given the same medical information. I'm distilling it. It was a complicated study that had two parts, but essentially they were given the same medical information and different demographic information about a decedent. So they were given all the same medical information about the decedent, but half of them were told that the decedent was white and half of them were told that the decedent was black. And the difference was stark. They came to very different conclusions about whether the death was homicide or accidental based on race, essentially.
Wow. Gosh.
Yeah. And so, this idea that, drugs and heart problems might also have contributed to a death of a person who was captured on videotape being deprived of oxygen, being mechanically asphyxiated for 9+ minutes. Those may indeed be true, right? But it does not mean that they were the proximate cause of his death. I think there's no question that George Floyd could have gone on, living happily and healthfully without, but for the police officer's knee on his neck.
Yes. Yeah. And that's just what I think she's saying it's just her opinion, but Alice is saying it was just the knee on the neck, in my opinion. The experts proved that not to be true, just my opinion.
Well, the experts were very clear. And this is the other problem, right? So forensic pathologists, when they write an autopsy report, they have to not only say the cause and manner of death, but they have to talk about the other things they found during the autopsy report. And I think once he was up on the stand talking about his conclusions, it became very clear that although he may have had other issues, this was the cause of the death. If you can imagine, I think it's very unlikely, right, that someone who had maybe a cancerous tumor, but they were shot several times, the autopsy would be obligated to write down the person suffering from cancer because it's an important medical diagnosis and it's part of the investigation. But it doesn't mean the cancer killed them.
Doesn't mean that,
If they weren't shot, then they would still exactly.
Yeah. They have to say everything when they do a full autopsy, don't they? So it's just a case of it has to be mentioned.
What's interesting, this is maybe a little bit of a deep dive, but there's a long history actually of police, of people of color, particularly young Black men dying in police custody. And there's a long history of medical facts being used to sort of explain away these deaths. So one of the earlier articles that I'm aware of is I think it was in Los Angeles in the late 70s or early 80s, there was some investigation done of young Black men who were dying in police custody. And some physicians were actually blaming, I mean, it's almost unbelievable to think of, but they were actually blaming the anatomy of these men for their death. And there's a long history, certainly in the United States, there's a long history of medical science, you know, blaming Black folks for medical science's own shortcomings, right?
Yeah.
Yeah, I just put that comment up that had Chauvin not placed his knee on George Floyd's neck, George Floyd would still be alive today.
Yeah, which is basically
I mean
the same thing as well.
Yeah.
Before I forget, because talking about CIFS, we did mention it in the last time you were here, but because it runs on donation, doesn't it?
Yes.
Yeah, and so that's something. So if any of you super mods out there can get onto the CIFS,
it's in my description. It's in the description. The link's in the description.
Yeah.
If someone wants to post it in the chat.
Please share it in the chat. Oh, somebody already has.
Yeah.
Cat Neat. She beat me to
about
a minute ago.
Super
Before
mod.
I even thought it.
Super mod cat mate.
But if you go onto that link anyway, you'll be able to see there's a little donation thing on there. So, you know, if you're inclined to, then please go and donate, because it is really important to have organisations like CIFS who are working towards, you know, making sure that everything is above board in that sense. You know, making sure that the forensic science that is presented isn't bogus, like plastic bags, you know.
Yeah.
I know that's not just what you do me to like minimize what you do to a plastic bag.
No, but I didn't know about some of these. I mean, before I started doing this work, I wasn't aware of some of these obscure types of forensic science that have been used to put people away. I mean, things like photogrammetry and this plastic bag comparison, which is called blown film analysis. I mean, it's all.
Oh. Well, there was one I read about a while back to do with the hair comparison. I can't remember what case it came from now, but it was like somebody had compared a dog hair and it matched up to the human hair, and they got convicted off of it.
Yes, I'm familiar with a bunch of the hair comparison cases. That may have been, I could be wrong about this, but I think that may have been Sante Tribble's case. And he was one of the folks who got convicted in, and then featured in that Washington Post series a few years ago on bad hair comparison. You know, hair comparison is in some ways a bit, I always hesitate to say this because it's not a success story. Like, people's lives were absolutely destroyed, but it is an example of a fairly effective systemic response to bad science. The FBI partnered with the National Association of Criminal Defense Lawyers and the Innocence Project to help identify some of these cases. And while there's still a long way to go, because we certainly have not had an opportunity to look at every state, and they've recommended a state-by-state analysis, it is at least an example of the successful collaboration between, you know, folks from all different parts of the justice system that, you know, that was able to at least provide relief for some people.
Yeah. Oh, that's good.
I suppose you can't say any of it is 100%, Kate, but what would you say is the most effective in forensic science? Like, I'm trying to think how to word this now. I know what I mean.
Well, I think I understand what you mean, but correct me if I'm wrong. So what the National Academy of Science has said is the most reliable area.
Reliable, that's the word I was looking for.
Yes.
What's the most reliable?
Yes, it's single source nuclear DNA analysis. So it's not all DNA. But it's the kind of DNA analysis we do when we like swab your cheek to check for, you know, paternity, right? Or when the blood at a crime scene is tested and found to be the blood of the victim, right? That's the kind of DNA testing that's been shown to be very reliable.
Yes.
Next, after that is simple mixture analysis. So that's like a rape case in which, swabs from the rape kit are tested and are found to show DNA from 2 different people.
Right.
But once you start to have more complex mixtures with additional contributors, that's where we start to see some degradation. It's not as reliable then.
Yeah.
Right. Yeah. When there's not just one clear person.
Or 2. Yeah.
Oh, yeah. Okay.
Mm-hmm.
And how many, so like, because you've got fingerprints, you've got hair, you've got blood, you've got, how many different sources are there? Like, again, I don't know, I can't get my question out what to explain. Like, so, like, you've got fingerprints and then you've got, like, hair, blood, like.
You mean how many different sources of DNA are there?
Oh, sources of DNA. Well, any nucleated cell in your body can be tested for DNA. So,
right.
Yep. So, any way that you would leave, so skin cells leave DNA, right? Sperm cells leave DNA. Epithelial cells, which are the cells that line your mucous membranes inside your mouth, that kind of thing. Those all leave DNA. So, I mean, any of those things can be tested for DNA.
Yeah. Thank you. I just wondered, that was all.
I've got a question actually about because I saw that you guys won that award, the Wisconsin Legal Innovator Award. So congratulations for that.
Thank you.
Thank
you.
And one of the, because I was looking on your website earlier, just having a bit of a refresh, and it said on there, one of the quotes was that everyone deserves a fair trial, which you said earlier, whether they're guilty or they're innocent, which is I agree with. And the question that I thought about from there is that because if you were to find that the forensic evidence in a trial was bogus, like that doesn't necessarily indicate that a person is innocent or guilty, though, does it?
Sometimes it can. I mean, it can be dispositive. So in cases that, we've talked about before, like our clients, Stephanie and Amanda, their convictions were predicated entirely on medical opinion. So doctors said that the deaths were homicide, and later it turned out that they were not, right? So that's an example of once the medical opinion is shown to be wrong, then they're not only not guilty, there's no crime.
Yeah.
And there are other examples like that too. If someone is convicted of a rape and a murder, and it turns out that DNA found at the scene belongs to somebody else, it's a very straightforward case typically. Other times it's less so. We've talked about how bite mark is a junk science, right? Bite mark matching, and there are cases in which people who are pretty indisputably guilty have been convicted in part with the help of bite mark evidence, but that in and of itself doesn't prove anything good about bite mark evidence, right? I mean, the reason why we suspect that people with those kinds of cases are in fact guilty is because we have lots of other evidence. And so that's sometimes what people are concerned about when we say this or that type of forensic science analysis is not reliable. But in general, when someone is guilty, right, and there's a thorough investigation, there's a lot more there besides, one sort of esoteric type of forensic science that convicts them.
Yeah, well, that's because the reason why I asked that is because there's a real in our community there's a real like truther or guilter, like you're either a truther or a guilty, you believe they're guilty or they're innocent. And when you see other people's, like, because we're the truthers, and then when you see the people who think that Stephen and Brendan are guilty, they'll kind of say things like, we're ignorant to real forensics and stuff like that. So the reason why I wanted to ask that is because, like, just because somebody's been convicted of something based on forensic evidence, it doesn't signify guilt or innocence, does it?
I see what you're saying. Yeah. So I think that when someone has been convicted in their trial involved forensic science, there are tons of cases, right, in which lawyers are proclaiming their client's innocence, fighting for their innocence post-conviction, and they were convicted based on forensic science and later shown to not be guilty. And similarly, bad forensic science can be used to help convict a guilty person. But what our organization is particularly concerned about is whether or not the evidence is reliable. And that is essential because if you are, for example, a victim of a crime, right, you deserve, a swift and appropriate resolution. You do not deserve and you should not receive a resolution based on evidence that is bogus or wrong or fabricated or inaccurate, right? And the same is true if you're accused of a crime. You are entitled to have a fair trial without anybody's thumbs on the scale. You deserve due process. You deserve fairness. You deserve not to have, lies and nonsense, right, included at your trial. And that's true whether you're guilty or not, because when we have a trial in our system, that's how we get to as close to truth as we hope to get. So we have to trust that process. We have to know that it's right, that it's fair. It doesn't guarantee, if forensic science is always perfect, it's still not going to guarantee that there's never a wrongful conviction, but at least it's going to go some way toward, getting closer to real justice in some of these cases.
And the thing is, forensic science is always developing because, once upon a time, you didn't have the luxury of DNA. So, in 10 or 20 years from now,
look what happened in Stephen's first case. There's an example of that because in the very beginning, when he was first convicted, they didn't have the forensic science to do what they did with the pubic hair. And it was years later, wasn't it, when it was retested and always
and that's a great example of something that happens in some of these cases, right? So part of what so we talk about this a lot in the innocence community, of which I used to really be a part, right, where we say we may never know whether something, whether someone did or didn't do something. We weren't there. We don't know for sure. But what we can do is we can investigate to come as close to that answer as we possibly could. And we can rely on other sort of credible information to help us get to that answer. So if you want to look at something like the first, kind of what we would call the first Stephen Avery case, you can look at the DNA evidence to show that eyewitness identifications are sometimes wrong. And people make, eyewitness identifications incorrectly, even when they're trying to do a good job. It's not their fault that our brains don't work that way. We are not 100% accurate. And so the same kind of thing is true with false confessions, which I know came up in Brendan Dassey's case. We know that confessions can be false. And so while we may never know whether any one particular confession is false, we can apply the lessons we've learned, using DNA testing and other things to say, this confession, while we might never be able to say this confession is false, we can certainly say this confession has all the hallmarks of these other confessions that are known to be false. So we can kind of create rules and apply them to help us get to the right result, even when we don't know exactly what happened in any particular case.
Yeah, exactly. Just to give you a heads up, we've got about 2 minutes left.
I just saw the time then, and I just realised that hour has just flown by, hasn't it? Flown by.
Such a pleasure talking with you.
So,
thank you for coming back.
Just before we say goodbye to Kate, I'll just say if you all head over to Just Rhonda now, I think Katnit has, or someone has put the link in the comments. But
I'm sure somebody else.
Just Rhonda is on next, talking about the Daniel Holtzclaw case. So so all after we've finished here, all head over to Rhonda.
Yeah, and thank you, because I haven't had my chat up on the side here. I forgot that it was there, and so I haven't been looking at anyone's comments.
I've been glancing over because I got a couple of the questions. But thank you so much for coming on with us again, Kate.
Yeah, absolutely. And thank you to everyone in the chat as well. I've seen that like everyone's been sharing the links and having a good old chinwag down there as well.
Yeah.
So thank you everyone for coming over and being on Jane's channel.
Yeah. Well, we'll go for a couple of minutes longer just to give Rhonda, because I don't want there to be any dead air in between. So we'll just I'll just make sure if someone could let me know when Rhonda's live.
Yeah.
And then
well, just as a last kind of question then, Kate, have you got anything that you're currently working on at the moment, like any cases Amanda and Stephanie that you're working on right now that are on the brink of something?
Yeah, we expect to have a hearing. In another unfortunate child death in March in Ohio. Our client's name is Alan, and we are going to talk about in our hearing. We're going to talk about how Alan was convicted of abusing a child in his care who was actually just profoundly ill, extremely, extremely sick. And it's been a wild ride because we've had, it's been quite contentious. And yeah, it's been tough. So I hope that we're able to get the right result for him. And, you can kind of see that we're also looking at other cases around the country, even when we don't represent a specific client. We have filed a number of amicus, of friend of the court briefs in support of people nationwide. And that's actually something that lawyers who have cases in which they'd like us to weigh in can contact us and request our help. We typically do them in situations where there's either a forensic science discipline that's known to have problems, or these cases that I was talking about before where it's like a one-off, like some weird test was developed seemingly only to implicate someone in a particular case.
Yeah. Okay.
Yeah.
And that's got a whole bunch of problems that comes with that, I'm sure. Yeah.
Right. Yeah. We're really concerned about, any situation in which bias and error has seeped into a case, maybe sometimes in an unnoticed way.
Yeah. Where it just seems normal and everyone's gone, yeah, that's right, convict.
Yeah.
Oh. Well, thank you again for coming to talk with us.
Thank you.
Yeah, and just again before we go, I just wanted to point out the reason we're here, because I didn't get a chance to say it at the start. Obviously, this is a tribute to our dear friend Eric Cozy, and he would have loved to have spoken to you, Kate, because he was a big inspiration to us to even start a channel, and he he was the one that kind of gave us the confidence to even ask guests like you to come on, because obviously anybody that comes on our channel we welcome, anybody in the community we love, but he kind of gave us the confidence to sort of think outside the box and realize that we can reach out to people like yourselves in this sort of wrongful conviction community, and he was a very big inspiration to us. So he would have been really pleased and really proud, and I know for a fact after the first time that we had you on, he would have reached out to you himself and he would have asked you to come on his channel, because he that's just what he was so passionate. He's passionate and drive for the case, and that's kind of why a lot of us are here, and a lot of us have our YouTube channels, because he was a big driving force behind it. So so
to Eric Cozy.
Yeah, to Eric Cozy, and thank you again for coming on, Kate. And anytime, we would love to have you back anytime, because we love talking to you, and it's always a pleasure.
Yeah.
So nice. Thank you.
Good luck with all your future cases.
Thank you.
And then obviously, guys, if you're watching, please go and donate because it's
yes,
it's very
the link's in the
important.
description,
Yeah.
and you can follow
Yeah.
Kate on Twitter. The links into this. The link is in the description for that, and also for Cif.
We're at Cifs Justice on all social media. So
Yeah.
I don't tweet much myself, but our wonderful,
Yes.
wonderful communications director, it does all of our social media.
Yeah, I've
Okay.
put the link for that in the description. So yeah, all guys go and shoot over to just Rhonda because I'm sure she'll be live now. It's a few minutes
probably.
past, so she'll definitely be live now. So yeah, take care everyone. Thanks for joining us, and good luck to everyone else. We've still got a good few hours to go yet, so I don't know what we'll be all like at the end of it, but it's been brilliant so far. Really good. I'm dead proud of everyone.
Yeah.
Dead proud of everyone. So take care and
Bye.
enjoy the rest of your night. Bye.
See ya.
Bye.